Welcome back to Case Closed, your go-to podcast for smashing A-level law revision. I'm Jade, and in today's episode we're talking about what happens before a civil court case even reaches the courtroom. Civil claims don't just start with a dramatic trial. There are often essential steps that must happen before a case is heard. Let's break it down. Before rushing into court, it's important to remember this. Court claims should only be considered as a last resort. That means trying to negotiate a settlement or use other forms of dispute resolution like mediation first. Only if those fail should a formal court claim be considered. The first formal step is to follow the appropriate pre-action protocol. These are often official procedures that set out the conduct expected of both parties before a case goes to court. They include steps such as exchanging information, trying to settle the dispute early, and setting deadlines for responses. The aim of this is to resolve as many issues as possible without needing a court hearing. If either side fails to follow the protocol, the court can penalise them later, even if they win the case. If all else fails, a claim may need to be issued, but in which court? It depends on the value of the claim. Claims under £10,000 or under £1,000 in personal injury go to the small claims court. Claims between £10,000 and £100,000 or up to £50,000 in personal injury start in the county court. Claims over £100,000 or over £50,000 in personal injury can go to the High Court or the County Court. It depends on the complexity. Choosing the correct court is key to managing time and costs properly. To officially start a case, the claimant must complete Claim Form N1. This includes names and addresses of both parties, brief details of the case, and the amount being claimed. The form can be filed at the County Court office, at the High Court for high-value claims, or online, especially for straightforward debt claims. A fee is required to issue the claim, and the higher the value, the higher the fee. Once the claim is issued, the court will serve the papers to the defendant. They now have several options. They could admit the claim and pay the full amount. That would mean the case would be then closed. Admit the claim but offer to pay in instalments. The claimant can accept or reject this. They could dispute the claim and submit a defence, or acknowledge service, which means confirming receipt of the claim and asking for more time to respond. However, if the defendant doesn't respond at all, the claimant can request judgment in default. This means they automatically win, and enforcement action can begin to recover the money. If the claim is defended, a judge will assign the case to one of the 4 tracks, depending on its value and complexity. Let's go through them. The small claims track is for claims under £10,000 or under £1,000 in personal injury. It's heard by a district judge, is usually limited to around 2 to 3 hours of court time, and is relatively informal, and often no lawyers are required. The first track is used for claims between £10,000 and £25,000. It's heard in open court by a circuit judge, and generally trials are limited to 1 day. The intermediate track was introduced recently, and this is for claims between £25,000 and £100,000. The trial lasts 3 days or fewer, is heard by either a district judge or a circuit judge, and is designed to handle moderately complex cases. The multi-track is for claims over £100,000. This is usually dealt with in the county court, heard by a circuit judge, and the judge sets a timetable for managing the case. Multi-track cases are often the most complex and may take months or even years to resolve. So, let's recap on what we've learnt so far. In civil claims, it's important to try to settle first. Court should be your last resort. Always try negotiation or ADR first. It's important to follow the pre-action protocols. These are formal steps that must be taken when going to court. Picking the right court is important. This depends on the amount being claimed. Issuing the claim is done by an N1 form which must be completed. Fees have to be paid and submitted to the right place. The defendant can admit it, fight it or ignore it, but beware, no response means the claimant could win by default. And track allocation. The judge will assign the case to one of the 4 tracks: small claims, fast track, intermediate track or multi-track, based on the value and complexity of the case. And that's it for episode 3 of Case Closed. Now you hopefully understand how a civil case gets off the ground before it ever reaches a courtroom. Next time on Case Closed, we'll be breaking down civil appeals. When things don't go your way in court, how do you challenge the decision? Make sure to follow the podcast so you don't miss it, and if you found this helpful, share it with another friend who's revising for law as well. Until next time.